I put it to you that the incident Ms. Mengo describes of you unzipping your pants could very well have occurred during one of those unaccounted for periods in the afternoon when your secretary was not in the office and also when we do not have the video footage.
What time was that?
Judge President Benenge indicated that the judgment on this leave to appeal application will be delivered before Christmas.
If you want to understand why South Africa was always going to stagnate, you should pay attention to what Singapore's founding Prime Minister said in 2009. In his characteristically blunt style, Lee Kuan Yew argued that India's greatest strengths on paper, which he said were its democracy, diversity and constitution, were also its greatest developmental obstacles. India, he said, was too divided to act with unity, too democratic to plan long-term, too legalistic to move quickly and too caught up in procedure to ever become an industrially developed state like China, Germany, or even Singapore. Now, if you replace India with South Africa, you land on a frighteningly accurate diagnosis of our post-apartheid condition. Like India, South Africa was reborn through law. The 1994 transition was not a revolution, it was a negotiated settlement, sealed by a highly legalistic, liberal constitution. That constitution became a moral compass and a symbol of unity, yes, but also a developmental straitjacket as South Africa gave rights without building state capacity and committed to transformation without centralized power. The result was gridlocked governance and an incapable state drowning in legalistic victories that would never translate into lived change. Just like India, South Africa became a democracy where every action is contested and where procedural performance substitutes for developmental delivery. Here, anyone with the financial means can successfully mitigate against the most progressive pro-people policies. This is what Lee Kuan Yew warned about, a system so entangled in judicial review and multi-stakeholder consensus that it cannot govern, plan, or reform. In South Africa, land reform stalls because of legal ambiguity, endless public consultations and tender disputes, while state officials are paralyzed, fearing litigation more than failure. Every crisis turns into a commission of inquiry and every proposal becomes a court case, and when something does break through, like when a judge, a leader, or a community forces the system to act in favor of the people, the system brutally punishes them. A case in point, the ongoing tribunal against Eastern Cape Judge President Selby Mbanenge. In 2022, Mbanenge, alongside Judge Gerald Blome, ruled against Shell's seismic blasting off the Wild Coast in the Eastern Cape. The judgment affirmed indigenous and coastal communities' environmental and cultural rights, blocked a multinational fossil fuel giant and undermined political elites aligned with extraction. This was one of the very few moments the Constitution was used against capital and in defense of the marginalized. And what happened next was a disciplinary tribunal, a media campaign and a sudden legal focus on alleged WhatsApp misconduct. However, what's really on trial isn't ethics, it's ideological disobedience. Mbanenge disrupted the unspoken rule, the law may speak of rights, but it must never block power, especially corporate power. This is the core contradiction of South Africa's post-apartheid order that Lee Kuan Yew spoke about, where a nation celebrates the constitution as a vehicle of liberation, but uses its proceduralism and hyperlegalism to neutralize disruption and transformation. Lee Kuan Yew's warning wasn't an endorsement of authoritarianism, it was just a realistic recognition that fragmented democracies and hyperlegalistic cultures tend to stagnate. South Africa is the case study. SA has capable leaders in government, the opposition, and the judiciary, yet it's moving backwards on most development indicators. The common thread isn't incompetence, it's a system where every meaningful change gets bogged down in the very procedural safeguards that were supposed to protect transformation. The uncomfortable truth is that you can't have both extensive constitutional protections and rapid, directed development. South Africa chose the former and got the predictable result. This is based on an ex-post by Sizwe Sikamusi.
The bone of contention in the application was whether there was meaningful consultation and the delay in the applicants coming to court instead of using internal remedies. Minister of Mineral Resources and Shell believed there was substantial consultation. The applicants argued that there was no proper consultation as the notice was published in 4 newspapers that do not circulate in the area. The notice was also published in English and Afrikaans, although the majority of the residents speak isiXhosa. The Mineral Resources Ministry questioned the time the applicants took to come to court, adding that they were aware of the planned seismic survey.
The other issue is perhaps more en passant, and that is the mention that the minister didn't become involved in the issue relating to internal appeal. Perhaps the answer lies here, my Lord and my Lady, is that the situation is possibly similar or comparable to a situation where a administrative tribunal organ or even a judicial officer is asked to recuse himself not because there is bias, because of a perception of bias. And it's probably prudent for the minister not to have got involved with that issue at all.
The applicants in the main application also argued that Shell did not have environmental authorization as per regulation to conduct a seismic survey. But Shell says at the time, when applying for the exploration rights for the first time, this was not a requirement. The petroleum giant believes another court will have a different view on the matter.
In order to get where the applicants have reached on the point of consultation now, they ought to have challenged Regulation 3 as unconstitutional and sought to have it set aside. And our submission is that in the absence of having challenged that regulation, they couldn't succeed in persuading this court, or they shouldn't have succeeded in persuading this court that there was inadequate consultation.
The respondents believe there's no prospect of another court reaching a different conclusion.
On each of the grounds of review, they effectively made new law. So they made legal findings which other courts in our legal history haven't gone as far to make those type of findings. So I'm not saying I don't believe that they were wrong at all, but it is important that a higher court such as the Supreme Court of Appeal would hear a matter such as this, because it is of importance not only to business, other stakeholders, but indeed to the whole country and the public.
Judge President Benenge indicated that the judgment on this leave to appeal application will be delivered before Christmas. SABC News in Gqeberha.
The alleged incident of the 14th or the 15th of November, where Judges Sekchi and Mengo alleges that Judge President Selvin Benenge indecently exposed himself to her and requested an act of a sexual nature, circled back before the landmark probe. This as evidence leader advocate Salome Skeppers revisited it during cross-examination, putting the possibility of the incident occurring to Benenge.
I put it to you that the incident Ms. Mengo describes of you unzipping your pants could very well have occurred during one of those unaccounted for periods in the afternoon when your secretary was not in the office and also when we do not have the video footage.
What time was that?
Just answer the question, please.
I can't answer a question.
It could have happened.
It did not happen. The issue is whether it happened. It did not happen. And on the objective facts that we have thus far, I think it's demonstrably clear that it did not happen. You can repeat this 200 times. It's not going to change the situation. This is becoming malicious.
In addition, Mengo previously testified that she attempted to resolve the situation through a roundtable prior to the complaint being laid, but Benenge did not attend. The top judge explained why.
I was initially amenable to attending the meeting, but on further reflection did not see the purpose in attending a meeting where I would be confronted with pictures that I had no knowledge of, more so in the presence of other persons. May I continue? Yes. I found it disconcerting to learn that the subject of the meeting was 2 pictures which I bore no knowledge of. I was unable to fathom why Ms. Mengo would, in those circumstances, want to confront me with these pictures. This, in the background of what she said, if you read these things together, then I'm saying to you, I could not attend that meeting. And thanks God I did not.
In addition, when Advocate Skeppers called on Benenge to reflect on the complainant's version that alleged advances were unwanted, the top judge remained unmoved.
If I understand you correctly, given everything that has unfolded here before the tribunal, Your messages, the language that you used, and the nature of the interactions, you've stated that you didn't believe that your conduct was unwelcome at the time.
I repeat everything that I said in chief and what I said yesterday. I still repeat it now.
The tribunal has adjourned. Kani Mapanga, SABC News, Johannesburg.
That's a wrap, folks. But before you go, keep this in mind. Their smoke and mirrors are just theatrics, pulling your focus from what truly matters. The real fight? It's always been about the land and the economy. Stay sharp, stay woke, and we'll catch you next time.
The most important person in the world is the storyteller. The storyteller sets the vision, values, and agenda of an entire generation to come. Steve Jobs.